Delegate Glass, House Bill 2063.
Thank you, Mr. Chairman. The committee, House Bill 2063 is a bill implementing the recommendation number 5. I got you. For the JLARC study.
Move the sub.
I know that. Yep, I'm getting there. The House sub.
We should usually adopt it before you start speaking to the board.
I'm not. I'm just
Okay.
saying what it is, if that's okay. Sorry.
Okay, sure. Go ahead and tell us what
Before I
substitute
get to the
is.
details, I believe there is committee substitute. Let's get in there.
I'm sorry, Mr. Chairman.
okay.
Move the committee substitute.
Is there a second? All
right.
in favor signify by saying aye.
That's okay.
Opposed? Substitutes before us. Delegate Glass.
All right, so yes, this is, again, the recommendation number 5 for the JLARC study, improving the Virginia adult and guardian conservative system. The substitute is a result of a discussion between the bankers associations, the credit union leagues, and the Association of Elder Law Attorneys. The bill was originally drafted put 5-day time requirement for fulfilling the request for records. The substitute removes that requirement entirely. Additionally, the bill, as originally imposed, penalties failing to comply for that timeline, the substitute removes that entirely. And it has been approved. So speaking to the bill, this is really uncomplicated. All it does is ensure that the court-appointed guardian ad litem can attain access to financial records or other information relevant to the adult who is subject to that guardianship. There's language in the bill specifying that this information can be only released when the request is accompanied by a copy of a court order appointing the guardian ad litem and authorizing the release of the recipient's information. It also contains language specifying that absent gross negligence or willful misconduct, the person or entity making these disclosures shall be immune from criminal liability. I'd also like to note that we have heard from the Commonwealth's Attorneys Association late last night who had some concerns about disclosing information on relevant or ongoing criminal investigations, and that they may have had some language. So if they are there for this, and I would consider what that is a friendly amendment. I have representatives here with me from the Virginia Association of Elder Attorneys, and I believe the Bankers Union as well, that can speak and answer any other questions with regard to the bill.
Thank you, Delegate Glass. Any members have questions for Delegate Glass? Anyone here in support of the bill?
Good afternoon, Amy McCullough from VELA. First of all, I wanted to thank Delegate Glass and her staff for working with us on some of the language for the bill. We had been talking to her office and also to the Virginia Bankers Association about this. As the delegate noted, this does come from a JLARC recommendation, and one of the practical problems that it would solve is that very often the court order appointing a guardian ad litem provides that guardian ad litem should have access to school records, financial records, medical records, but the financial piece is not actually in the statute. And so we've been getting pushback from some of the banks on that. We've also heard from some banks who have asked, could you please put this in the statute so that our people back in the back office know what's going on here, because we don't always get guardian ad litem orders every day of the week. So this is just a practical fix that makes it easier for guardians ad litem to do their jobs and make full and complete recommendations to the court.
Thank you. Anyone else here in support of the bill? Anyone opposed? A motion and a second to report substitute on House Bill 2063. Delegate Leftwich, you have a question.
Just a question. So I'm looking on page 3, line 60. It says the records shall be provided at no charge. Then below it says the bank can, or whoever's providing the records, can provide a statement of expenses or invoice for the court to award costs. I'm just wondering how those two provisions interplay with one another.
What line is that?
Well, it says the records, and I don't have a problem with it being, provided at no cost necessarily, but on line 60 it says all such information, records, and reports shall be provided to the guardian ad litem at no charge. But then it goes on to say that whoever's providing the records can submit an invoice with the records to present to the court for the court to consider in determining, I guess it's an award of expenses and stuff. But I'm wondering how they could recover those expenses if we've said by statute they are not allowed to get recovery for it. Am I making sense?
You're making perfect sense.
Okay.
I'm looking at it. You said lines. I
Maybe
think
council could
Yeah,
address
could
that.
help me out with that language. Thank you.
I understand.
Mr. Chair.
I do think they are in conflict. I don't know. I don't want to speak for Delegate Glass, but I think what it is that we're saying they can't be charged, but if they want to provide a statement, the court could reimburse them for whatever their cost was. But I don't think it would be mandatory.
I can't see a court doing that.
Anyway,
All right, I don't want to get your bill of fever. I was just curious.
Yes, Mr. Chair. Thank you, Delegate.
Okay. Delegate Ballard, you have a question?
Mr. Chairman, quick question from someone else. I'm just curious the background of the discussion of how we arrived at the gross negligence standard to determine immunity.
So I
That's not, if you can answer, that'd be great.
I believe so. I might turn and look backwards, but I believe that was already a part of the, if I'm saying this correctly, the standard for, I'm looking at you. Oh, where? A standard for the
It's one of the standards, as I understand it, this is
Power
not
of
my
attorney.
primary area of practice. Should I come
Power of-
Yes, please
come
come
up.
forward.
Sorry, for the power of attorney. I believe that's where it came from.
Banking law is not my area of practice, but my understanding from the Bankers Association in our discussions is that this is the standard that they're subject to under their federal banking regs, and so we're trying to not conflict with their federal obligations.
Understand. Speak. Yeah. Just give us the thumbs up if that's correct. Okay.
Thank you.
Did that answer your question, Delegate Bell? It does, thank you, Chair. Okay. So we have a motion and a second to report the substitute on House Bill 2063. All in favor signify by your vote. And close the roll. Bill report 7-0. Thank you, Delegate Glass.
Thank you, Mr. Chair.